the people to feel good about themselves, right? People who waited patiently, people who participated and took the time to sign an affidavit, get it notarized, who didn't mind their name being out there, who wasn't fear of retaliation by the government, who said, I just want to have my voice heard. Well, your voice got heard, and I can show you what I mean by that. So let's go through the opinion real quick. An exceptionally concise, well-written, well-analyzed decision by Judge Torres. Very methodical, very simplistic. She stuck to the facts and the law and gave her decision.
On July 13, the United States District Court for the Southern District of New York in the United States handed Ripple Labs a victory in a dispute that had been brought before the court by the Securities and Exchange Commission as far back as the year 2020. Annalisa Torres, the judge who presided over the case, came to the conclusion that the company should be allowed to continue operating. According to the documents that were submitted on July 13, it appears that Judge Torres has ruled in favor of Ripple and granted a summary judgment authorizing that the XRP can be used. According to court records obtained by Cointelegraph and viewed by US, the SEC filed a complaint with the goal of pushing Ripple to halt the sale of its XRP coin on the grounds that XRP was a security, and as such RIP was a security and as such required greater scrutiny and regulation. The defendant's move for summary judgment is granted in relation to the programmatic sales, the other distribution and the sales that were made by Larson and Garlinghouse. Nevertheless, the request for summary judgment is refused. Additionally, the motion for summary judgment is denied in regard to the institutional sales. The value of the token has increased by more than 60% since December 2020 when the SEC filed a lawsuit against Ripple and its two top executives Brad Garlinghouse and Chris Larson over charges that the business was issuing an unregistered securities offering. After the news broke, the price of XRP has decreased and it has continued to fall ever since. The action against Ripple has been going on for some time and is currently being heard in court. Over the past 3 years, the case has seen its fair share of dramatic intrigue, including the disclosure of the Hyman documents and continuous resistance in the face of the SEC, claims from Garlinghouse. In addition to the discernible movement that was demonstrated by the XRP coin going up in price, in response to recent news, both of these events are evidence of the case's spectacular development. The cryptocurrency community as a whole appeared to be in a state of elation. Ripple Lab was found not to have violated any provisions of the federal securities law when it offered its XRP token on public exchanges as determined by a judge in the United States. The decision made by District Judge Annalisa Torres of the United States District Court was the first time that the United States Securities and Exchange Commission was defeated by a cryptocurrency corporation. Despite the fact that the ruling was based on the particular facts of the case, it is highly probable that it will serve as ammunition in future legal battles between cryptocurrency companies and the SEC. This decision caused the value of XRP to skyrocket as a result. In addition to this, the ruling offered the SEC a degree of victory on a number of different fronts. A judge determined that Ripple broke federal securities law by selling XRP directly to skilled investors, and that Ripple should be held accountable for its activities as a result of this ruling. A trial should be convened to determine the role that Ripple executives played in such transactions. This trial should take place since the judge ruled that Ripple violated federal securities law. It is possible to contest the verdict by lodging an appeal with the proper court. A spokeswoman for the Securities and Exchange Commission stated that the regulatory agency is currently analyzing the judgment. In a statement that he published on Twitter, Ripple's chief legal officer, Stuart Alderoty, referred to the judgment as a huge win. He said this because the verdict establishes that cryptocurrencies do not function as securities. The SEC had accused the company, as well as its current and former chief executives, of engaging in an unregistered securities offering to the tune of $1.3 billion by selling XRP, which was initially developed by Ripple's founders in 2012. This allegation was made in relation to the sale of XRP because it disagrees with the SEC's position that the great majority of crypto tokens are securities and are consequently subject to its rigorous investor protection laws. The cryptocurrency industry has been keeping a close eye on the matter. The government has initiated more than 100 crypto enforcement actions saying that various tokens are securities. Despite this, a sizable portion of those lawsuits have been resolved by the negotiation of settlements in the extremely few instances where they have been brought before a judge. The decision of the SEC physician that the cryptocurrencies at issue were securities has been upheld by the judges. This is due to the fact that purchasers did not have a reasonable expectation of profit tied to Ripple's activities. She explained that those sales were blind bypass transaction, which meant that the purchasers could not have known if their payments of money went to Ripple or any other seller of XRP to Core is utilized a ruling from a case that was heard before the United States Supreme Court and stated that an initial coin offering, ICO, does not meet the legal definition of an offer of a security under the applicable statute. Torres came to the conclusion that Ripple's sales of XRP on public cryptocurrency exchanges did. It was determined by Torres that the company's sales of 728 million XRP to hedge funds and other skilled customers amounted to unregistered sales of securities. Ripple's marketing efforts that were directed at institutional investors made it abundantly clear that the company was promoting a speculative value proposition for XRP, which was dependent on the company's efforts to develop the blockchain infrastructure that was underpinning the digital asset. This was made clear by the fact that Ripple's marketing efforts were directed at institutional investors. Torres came to the conclusion that this made it abundantly clear that Ripple was promoting a speculative value proposition for XRP. In addition to this, she stated that the question of whether or not Garlinghouse and Larson assisted the firm in breaking the law should be decided by a jury, and breaking the law should be decided by a jury and, according to what she wrote, SEC are unable to use the defense that they were not given permission to do so. Fair notice that XRP was a cryptocurrency during the trial. The law does not require the SEC to warn all potential violators on an individual or industry level. She added this applies to both individuals and industry according to a representative for the Securities and Exchange Commission. The regulatory body is satisfied with those rulings. In a tweet, Garlinghouse expressed his joy at the decision that was made, thankful to everyone who helped us get to today. Fair notice that extra currency during the trial response to the request for a statement from an attorney who represents Larson was not received soon away. According to Gary, an attorney, the ruling is likely to be beneficial to Coinbase in this matter. The reaction of the market demonstrates that the verdict is a tremendous event for the industry. As he put it, in both the Ripple and Coinbase cases, the primary focus is on whether or not specific types of digital assets fall under the definition of securitization. As he put it, in both the Ripple and Coinbase cases, the primary focus is on whether or not specific types of digital assets fall under the definition of securitization, as the issuance of securities is subject to severe regulations and issuers are obliged to register their offers with the Securities and Exchange Commission. SEC and investors are required to be fully aware of any potential dangers associated with the security. We will stop here for now. Please don't forget to like and subscribe for more update on XRP news. Thank you and see you in the next one.